And this time we'll start with some trademark disputes around Twisted Sister. I'm going to explain why in a minute. And after we've talked about that, I'll also be here to answer any questions you may have for me, whether it's about trademarks, about branding, about entrepreneurship, about me, about Russia, about really anything you want to ask. If you have a question you want to ask, just put it in the comments below, and we'll take it from there. Now, so why Twisted Sister, and why trademark? What do trademarks have anything to do with Twisted Sister? So, why Twisted Sister? We just got an endorsement from their lead singer, frontman, none other than Mr. D. Snyder, and extremely proud to have that because I'm a big fan of their music. I remember, we'll get to this article in a second, but I remember that when I was growing up, my dad brought me a videotape from some compilation by Kerrang, and funny enough, so in the beginning it had the logo of Virgin Music, and I really didn't know the branding back in the day, and so I thought it was Virgin Heavy Metal. And one of those songs was it? I Wanna Rock by Twisted Sister, and it's a great video, of course. And I remember growing up on that, and there's a million songs from Twisted Sister that I really like listening to and like drumming to, and for us to get an endorsement from D. Snyder for our trademark registration services was quite something, because they have quite a story with their own trademarks. And before I get to what's described in that article, I want to draw your attention to something. So they're one of those bands that realized that being in show business is not just about parties, playing music, and having fun. It's about the business. And their guitar player, J.J. French, knew that probably better than most musicians out there. And what he did, as soon as he came up with the name of the band, Twisted Sister, was one of the first things he did back in 1977. I'm going to show you all the documents in a moment. They trademarked the name Twisted Sister. Again, 1977, that was years before their first album. That was when they were still playing clubs and bars, had no money, were trying to figure out their sound, and but what they had was the name trademarked. And as the band evolved, they had a hiatus. They came back to play more shows, and their long-standing drummer died, and they played a few more shows with Mark Portnoy. And the reason people kept coming back is because of the brand that they built for their band name. And it was very smart decision early on in the day to own that, because now they don't do any more shows, but the brand still has value. The brand still keeps paying them and will continue to pay them for the rest of their lives. So that's why I want to talk about it. And I found this article on Blabbermouth. It was published many years ago. I think it was like 8 years ago in 2013, if I remember correctly. So it's not news of the day today, but there's still a lot that we can learn from this article. And so I'll quickly skim through that, and most of it will be basically me providing my comments about my comments. Sorry, I was just seeing the chat. and we'll answer all the questions in the chat in the later part of this live. So where I was going with this, so I'll quickly skim through this article, and most of it will be just me providing comments and the lessons that you can learn from this situation, right? Okay, so this was an interview with D after their lawyers, really, J.J. French's lawyer sent a cease and desist letter to a Kansas coffee shop, which was called Twisted Sisters Coffee House, I think, in Kansas, and they demanded that the coffee house change their name to remove the words Twisted Sisters from it. Okay, and D said JJ is very crazy about protecting the trademark, and he sues everybody. That's true. You said people are going crazy because it seems like this Goliath is attacking this David, this poor little David for the Twisted Sister trademark. I told JJ, I said, man, you've got to call in some of these TV shows and some of these radio shows and defend yourself, because he apparently tried to work something out with the people at the shop, and the first response was, who is Twisted Sister? They actually said that they never heard of the band. Really, that much I know, right? Everyone's heard of Twisted Sister. For better or worse, it's a household word. The response that they got was pretty mean. Funny enough, it remembered me my own personal story with my father, right? This is how I got into whole intellectual property business. If you don't know that story, back in the day, I was still in law school in Russia, and he heard his music used in a radio ad for Samsung for an event that they did. Nobody asked his permission, and so he called them up. He called the radio station and said, "Hey, you can't just take my music and use it without my permission." To which they said, "Well, you got to be grateful that we're making you more famous with this commercial." And he was absolutely pissed, right? That was not the answer they should have given him. So I had to take this to court, and we won after a couple of years. But same idea here, right? You don't respond that way, because even if they did initially even if they had no idea initially, the owners of that cafe, and this is something I can't believe. What I cannot believe is that after operating under that name for some time, that no one brought this up to them, right? That I find completely unbelievable and unrealistic and improbable. So if that's the case, right, by the time they got the letter, they knew that there may be some claim coming from the band. And responding that way, such a dismissive manner, is never a good way to talk to right owners. So moving on, back on the article, right? So the two founders, the sisters operating the mission shop, told the Prairie Village Post that the name for a store, which started in August of 2012, is a reference to a family label given to the sisters by their late brother back in the 60s. And the reason they had to mention 60s is because they needed to show that the name came up before J.J. French started the band. Right? They wanted to have a story that would back up that. Right? He used to call Nancy the Blonde Tornado. So Twisted Sisters and the logo, which looks like a tornado sketch, are rooted in family and their Kansas location. So again, the reason that's the story they're putting up is that they have to explain to the world, and really when you're doing an interview like this, you're not really talking to the people who are going to read the interview. You're talking to the judge, potentially. And that's what they're doing, right? They're starting to build a story because when it comes to litigation, when it comes to going to court, it's really never about who's right, never about who's wrong. It's about who's got the better story. And you can play around with stories all day long, right? That's what attorneys do. That's why you hire them, because facts are facts. It's how you present the facts that matters. And especially in situations like this, when it's potentially a David and Goliath situation, right? The one interpretation of the story is that you've got this mean, emotionless machine that tries to, squeeze every last penny from the from the weak David, and David is the victim, right? And you want to paint this from the perspective of David was doing everything right, and nevertheless still got attacked. And please, judge, protect David against this meaningless aggression from the Goliath. So that's one part of the story. The other part of the story is, of course, that, hey, we've got this really successful business, really successful brand, Goliath says, and everyone and their brother wants to take a piece of the action. All these parasites are trying to take a free ride on the popularity of the brand that we've built. And again, this is what happens in a courtroom, right? One side tries to convince the judge that it's one situation, and the other side tries to convince it's the other situation. And the law only starts mattering once the judge has made the decision which side is more believable, and which side is more likable. And that's why when you have a potential for a dispute, your number one task is to create that story that the judge is going to buy into. And you have to tell that story everywhere, in your interviews, on your website, like everywhere, right? And whether or not that works is a different issue, but I guarantee that it won't work if you don't have a good story. So they're saying, okay, that's how they named us back in the 60s, and we use tornado because it's Kansas. I get that, right? And they say that the owners hadn't heard of Twisted Sister before receiving the letter. Again, I find that hard to believe because it's, 2012, 2013, right? It's Twisted Sister may have never gotten as big as, Metallica and some of the bigger names, but they're still enough well known, right? Enough people know about them. I find it absolutely unbelievable that over the months, not one customer told them, by the way, I also love Twisted Sister, that's why I come to drink my coffee here. If it's a very small shop. So they would have known, right? And again, here they say, quite honestly, when I first received your letter, I truly had to go to the site you provided to learn of this band. Sorry, after Elvis, the Beatles, and the Beach Boys, my love of music tends to be country, she wrote. Yeah, so again, this dismissive language doesn't really usually work to your benefit. All it does is piss off the other party. And even if you're right, especially when the other party has got the money to go after you, as Twisted Sister does, right? The more you piss them off, the more they want to fight, the less they want to come to a solution that would work for both parties, right? And then they say, honestly, we're a 1,000 square foot coffee shop in Middle America, and I would hope our sense of family, honesty, and community would be Twisted Sisters coffee shop legacy, with being a friendly, comfortable place to come and enjoy a great cup of coffee with friends and family. Now, in November of 2012, J.J. French released a statement explaining that he was forced to send a cease and desist letter to the owners of the Twisted Sister House of Hunger food truck in Minneapolis, Minnesota, asking the business to change its name because he and his bandmates are required by trademark law to either defend their trademark or lose rights to it. So this is a great concept that I really want to talk about on this live. Because you hear it all the time, right? Somebody sends the demand letter, they go to the press and say that the Goliath is attacking David. Happens all the time. And then Goliath said, well, I'm actually a good guy, but I gotta defend my trademark because if I don't, I'm gonna lose rights to that trademark. And that's why I'm fighting you, right? I probably wouldn't want to fight you, but I have to fight you because if I don't, I'm going to lose rights to my trademark. So let's talk about this for a second. Is that true? Yes and no. So the true part about this is that if, let's say, in a trademark litigation, if the defendant who's being accused of trademark infringement, if they can prove that the owner of the trademark has failed to defend their trademark in similar situations, thereby showing the world that they don't care about their brand anymore, then the judge in that trademark litigation case can say, yes, this is no longer a trademark. It's not as important anymore. Actually, so I'm seeing that I am being requested to speak a little louder. Give me 1 second. I'm going to see if I can do that. I think that's as high as it goes. Sorry, guys. How bad is it though? Is it really quiet, or should I keep going? Okay, a bit quiet. All right. Well, we'll try to fix it for the next one. Okay, thanks. So where was I with this? Yes. So the defend it or lose it, right? So if they can prove that the plaintiff has shown disregard to their own brand, that they're no longer protecting it, then the judge would say, yeah, they can't enforce it against this particular defendant either. But this usually means more than one particular situation, and also how far you go in defending, right? And usually what happens is the way to deal with that is not necessarily sue people, but you would send out demand letters showing your discontent, and you try to come up with formal settlements. You either let them use it or you have them change their name, things like that. Would it necessarily mean that you have to sue every single one infringer? No, it doesn't mean that. But if any future defendant can demonstrate a pattern that you knew and didn't take any action, then yes, this could become a problem. So this is why I said it's both true and not fully true that you have no flexibility whether or not to go after any particular food truck or coffee shop. So, but in this case, they made the decision to go after them, and we'll talk about whether or not they were right. But let's keep going. All right. In the cease and desist letter, which was sent last October, French and his attorney wrote, "It is the opinion of our client with which we concur, that your use of the name Twisted Sister will cause delusion of our client's famous mark and will cause confusion among consumers. The reason they worded it that way, and it's very precise language, really. When they say client's famous mark, the reason they had to mention client's famous mark is because their trademark registrations don't cover coffee shops, right? They have 2 trademark registrations, and actually let's go through them right now. The first one that they did, and I mentioned they filed it in 1977. Let's see. Let's have a look at that on the USPTO's website. All right. Yeah, there we go. So the first one they filed in 1977, and that was a trademark. Took them what, a year? Yeah, about just a year to get registered. What they filed this trademark for was Class 41. So that's entertainment services rendered by a vocal and instrumental group, right? So you see it here, and they claimed use back to 1973 when they first started playing clubs, right? And owned by John French, right? So his stage name was J.J. French, and he owns this as an individual, which is another interesting point here, right? So they didn't own it as a corporation. They didn't own it as a partnership. He owns it just himself, one guy, right? They probably have some sort of an arrangement in terms of what happens, but the reason it's so important, so he started the band. He owns the brand, the trademark for the name of the band, and what this means is that band members can come and go, right? New guitarists can come, new bass players can come, new singers can come, new drummers can come, but none of them owns the name. JJ does. This prevents a lot of stupid situations with multiple versions of the band when a member leaves and say, well, I'm also going to be, we had the situation with Quincereich, we have the situation with Great White, so many of those with Rat, with LA Guns recently. So we have this happening all the time, especially as the band members get older and they realize that really they don't play any new music anyway, and even if they do, nobody cares. So they go back to doing the nostalgia act. And I'm not saying it in a bad way, because I mean I used to go to these concerts when I could, as much every time I could, and I was one of those members in the audience who just wanted to hear the songs that I grew up with. And so where I'm going with this is J.J. French, by owning the trademark, made sure that he protected it in his own name. So this trademark was Class 41, Entertainment Services Class 41, and they also have another one, much more recent, and the new trademark that they filed was in Class 25 for apparel. And so outwear, namely jackets, coats, hoodies, scarves, vests, swimwear, all of that wonderful stuff. Also for Twisted Sister, and they filed it in 2017, right? So it took them 40 years? 40 years to file a trademark in a class other than 41. So that was not a great decision, because they really should have done it much, much earlier, and they should have protected their other assets. But you see, they got 41 for entertainment, they got 25 for apparel. None of those cover anything even remotely related to coffee shops or food trucks. So the reason that they can and do make those demand letters is when they say, well, our mark is so famous that we're protected well beyond the classes for which we have a registered trademark. And you have to make a case in a court, and sometimes you can, and you'd be successful, that, hey, we've sold this many albums, we've been, we've got so many platinum records, and we've sold so many, show tickets, and we've been active for 40 years, and everyone who hears the name immediately thinks of us. That's why we should be allowed to go beyond just the Class 41 and Class 25 and stop other people from misusing our name to take a free ride on our reputation. Right? That's why they have to make this reference to client's famous mark. So addressing criticism from fans and other observers regarding their decision to initiate the name dispute, French said, I get how stories like these appear, like David and Goliath. I also get how easy it is to take cheap shots at my band because of our former image and the 80s era MTV iconography. I really, really hate this new culture when if you own something and you go ahead and defend your rights, there will always be those articles. TechCrunch is notorious for that, and some other publications that just like, why do you go and defend your IP? It should be everyone's. Everyone should be able to use whatever you created. No, it's your property, and there's nothing wrong with defending your property. Even if it does appear like David and Goliath, right? As long as you don't act like a complete jerk, you're doing the right thing by defending, and I think you should never apologize for doing what's right. So, and then he says, the fact of the matter is that trademark law doesn't give me a choice on who and what to defend. The law is very clear. You either defend your trademark or lose rights to it. So we covered that. Over the last 35 years, that's an interesting one. I have defended my trademark against the biggest companies, Six Flags, Urban Decay, Harley Davidson, as well as dozens of mom and pop companies. The defense is almost always the same. They first claimed they never heard of the band, and then they said that no one would confuse the two anyway. I have won every case. The unique juxtaposition of the words twisted and sister have never ever appeared in print prior to my band's use of it. This was established in the Six Flags case. The name is so unique, like Led Zeppelin, and that any use would confuse the marketplace as either the product or service is owned or endorsed by us, right? So they had a court case, apparently, with Six Flags, and again, they didn't have anything to do with performance of a vocal and instrumentalist group. It would probably still be Class 41 for entertainment, but just because it's the same class really doesn't matter, because you can coexist with very different things even in the same class, right? And if I let one go, he says, that just emboldens someone else with the rationale that, hey, you didn't bother them, why go after me? I've heard this many times before, and that's true, because this is funny because he's been doing this for years, and after a while, when you're fighting for the same thing with different people, you know exactly what they're going to say, right? When I lived in Russia and was helping my dad fight pretty much everyone who would use his music without permission, that's again how my career started. Right? Before I left Russia, there was not a single federal TV station that I had not sued successfully for them taking his music without permission, right? And the arguments are always the same, right? You hear the same thing over and over and over and over again, and every time they say it, they think that they're the first ones to say it. And you're like, yep, okay, I've seen that movie too, you just do the thing you do, and they do the thing they do. So the funny thing is, he says, yeah, first they say they don't know who you are, then they say that there is no confusion, and you win anyway. So, of course, having those cases was super useful for him, and the only way he could win those cases is still because he trademarked the name. Even though now he relies on the famous trademark, famous mark, famous name that goes beyond the registration, the only reason he was able to get to that point is by owning it early on. All right? Here's an interesting story how they came up with the name, right? So he says, when my band first started, right, we thought of calling ourselves the Max Factor. It was a cute idea because we were a glam band. And my lawyer at the time then said to me, this is a bad idea for two reasons. One, you will probably be sued for trademark violation. And two, why would you want to trade on someone else's idea? Think of something original and unique. This way, should you succeed, you will be able to take credit for your own special creation. And this really is brilliant advice, right? This is something we tell our clients all the time, because you don't want to play a lose-lose game, right? You can't build your business hoping that you'll fail. It just makes no sense, right? You can't build your business hoping that you'll stay so small that nobody's going to give a damn about you using their brand or a brand that's non-distinctive. And that's the only way you could get away with something like this, right? So what his lawyer said exactly, right? You'll either be sued for trademark violation, you'll pay them all the money you've made under this brand, probably even more. Even if that does not happen, or maybe in addition to that, if you build your business with a brand that you don't own, then no matter how successful you get, you will still have a business with a brand that you don't own. And the bigger you get, the more important it becomes. The last thing you want to do is have to rebrand in the middle and explain to people why you're rebranding and all of that stuff, right? It's much easier and much safer to come up with a name that you can own early on, before you get big, before anyone wants to take advantage of you, before anyone wants to take that free ride, and own it, right? That's exactly what he did. Just following up with this, I really don't understand why people feel the need to steal someone else's property. Perhaps they're just lazy. I think the real reason is they used our name and they didn't call it the Beatles, Rolling Stones, or Motley Crue House of Hunger, is that they knew that they would get sued and perhaps thought that we wouldn't notice. The interesting thing about these ladies in Kansas, so they started in 2012, and they got this demand letter. Then everything got quiet, right? So either they settled, they probably did, because again, if JJ took them to court and lost, we would have heard a lot about it. That didn't happen. And it was just quiet after that. And if you Google, you would see that they closed their shop in 2018. So they operated for a few years. And then now there's another coffee shop under a totally different name with different owners there, same place. And this is exactly what happened here, right? So they probably figured out a way to continue operating under that brand. But by signing something, again, I wasn't there. I'm just guessing, right? By having them sign a piece of paper, that protects the band from this accusation that they didn't defend their mark. Because even giving a license for $1 to use this brand is enough, right? Because it means that they still enforce their trademark rights. Enforcing rights doesn't mean you have to sue people. Enforcing rights doesn't mean you have to sell licenses for some outrageous amount. It just means you don't allow people to use your brand without your permission. And so, but the story here is this, right? So they operated under this brand for some time, and puff, nothing, right? And that's what happens when you try to build a business with a brand you don't own, right? You either get sued or you end up with a brand that you can't own, with a brand that you can't have, with a brand that you can't grow, with a brand that you can't really do anything about, right? And look, I know that there are two categories of entrepreneurs. One category wants to build $1 billion business, and that's a great category of really ambitious business owners who know that if they spend any time, money, and energy building something, might as well build something that's successful, right? But I also realize that there are entrepreneurs and business owners who just want to stay small and they want to run their little shop in Kansas. There's nothing wrong with that, really. It's a lifestyle choice, right? You don't want to expend too much energy, money, and time trying to build, another Starbucks chain. I get that. But if you're in that boat, when you know you're going to stay small, then the name doesn't matter, right? The name at that point doesn't matter because you're so small. People are still going to be coming to your shop because they like you. You're probably a nice lady. You probably do some good coffee. People feel good at your shop. Great. Then it doesn't matter what the name is. So even then, you still don't want to come up with a name that can run you into problems, right? And there's nothing easier really than to see what's out there and see if that's a name you can own, right? And again, the cost of getting a trademark, right, regardless of who you do it with, even if you do it with the most expensive law firm in the world, the cost that you're going to pay to own the unique name that you came up with is still 10, 20, 50 times less than what you'll pay going through a lawsuit. So that's where I was going with that. All right, let's see if there's anything else in this article. No, not really. That's all I want to talk about Twisted Sister here. And before we get to the Q&A, and I'm really excited to answer all of your questions and just be here for you and have this conversation over the camera. Before we get there, just to be done with Twisted Sister, if you were here at the beginning of the stream, you heard me say that the reason I chose to talk about Twisted Sister is because we just got their endorsement, and I'm so freaking proud of that. I'm so happy that we. Again, for me, as a fan of their music, to hear Dee Snider say the things that he says about the business that I built, it's just, it's unreal. It's absolutely unreal. So while I get a sip of my tea before I get to answer your questions, what I want to do is just let you watch that quick video from Dee, and I'll rejoin you in a moment.
Oh, yeah. It's me, Dee Snider from Twisted Sister. Yeah, you know me. Now, more than 40 years after my band started, it's crazy when I think that several generations of metalheads grew up headbanging to my music. There are several secrets to our success and longevity. The makeup, of course, the controversy, the songwriting, all had a lot to do with it, but there's one thing that very few people know about that I want to share in this video. From the very early days, we knew that if we wanted to get somewhere in show business, we had to own our band name, Twisted Sister, and what a name it was. There's literally no point in building a brand unless you own your name. So one of the first things we did in 1977 was we went ahead and trademarked the name Twisted Sister. Just to put things into perspective, this was 5 years before we released our first album. We were still playing bars and trying to find our sound. We had no management, no record label, and barely any money. We had the name and our trademark, Twisted Sister. That's what we had, baby. And why? Because we were serious about making it big one day. And you just can't do it if you don't own your brand. That's why I want to give a big shout out to Trademark Factory, the only firm in the world that offers trademarking services with a guaranteed result for a guaranteed budget. You pay once, and that one fee covers everything from filing to registration. Trademark Factory can help you trademark your brand in the US, Canada, and pretty much anywhere else in the world. And the best part is, if your trademark doesn't go through, you get all your money back. Nobody else does this. Only Trademark Factory does this. So if you want your trademark done right with a 100% money back guarantee, check out Trademark Factory and see if they can help you protect your brand. I only wish Trademark Factory was around when Twisted Sister was starting out. It would have been a hell of a lot easier to trademark our brand. Trademark Factory. Yeah. Or should I say, Trademark Factory! Yeah.
There it is. I sold that. So super happy.
Oh, yeah. It's me, D. Snyder from Twisted Sister.
We've taken that out of the way. We probably don't want to listen to this again. Let's talk about your questions to me, and with some help, we'll see your questions, and I'll be giving you my answers. Let's do that. Do we have any questions so far? Do we have any questions? All right. Looks like we are experiencing a little bit of technical difficulties. Let me see. Let me see if I can fix that. All right, guys. One sec. Aha. All right, we fixed it. Technology. All right. All right, let's see it appear on the screen. And it's almost there. So let's close this down and then go back to here. There. Okay. All right. Don't shoot the piano player. All right. Question from Benevent Auctions. What about your own name as a brand? Pros and cons. Really depends. Really depends on whether your name means anything to anybody, right? Ford is a name, personal name of somebody, and he built quite a brand out of that. And Smith and Wesson is also people. Hewlett Packard, also names. So there are situations when your personal name can become quite a brand. For individual names, Tony Robbins, another one. And so if really you are at the point when you are micro celebrity or just a celebrity, then it may work. And it also depends how unique your name is, right? If you got a very common name, it will be harder to protect. If it's more unique, then you got more possibilities around that, right? And you can also have your name plus something else, right? And then you'd have the name with maybe a descriptor for what you do. So there are pros and cons. You really can't answer this question properly without doing a proper comprehensive search to see what's out there, and without knowing what the name is. But there's one of the trademarks we did, now that I think about it, and that was actually very useful. We trademarked the name for one of our biggest clients, Dan Locke, right? So we filed and registered over 150 trademarks for him. And one of those trademarks was just Dan Locke. The reason it was helpful for him is because when he was exploding on the web, he saw so many fake accounts, social media accounts pop up, like fake YouTube channels, fake Facebook groups, all of that stuff. And it was harder for him to deal with them when he didn't have a trademark, because once he had a registration, all he had to do was just fill out forms through those platforms, and they would take down those groups like this. So there are situations when trademarking your own name and picking your own name as a brand makes a lot of sense. But the obvious con, of course, is there going to be a business without you in it, right? So pretend that, I don't know, 30 years from now, you are no longer running this business. And let's say somebody buys this business from you. Would they have any reason to keep the name? If the answer is yes, then yes, by all means, it's a good brand. And with you out of the business, they will immediately, change the name. You were Bob Smith, and let's say James Brown buys it from you. If they have zero desire to keep Bob Smith and they want to become, James Brown Restaurant, then there's very little value in owning that brand. So again, think whether the brand can transcend you as an individual. If the answer is yes, then yes, trademark that. That could be a valuable brand. If the answer is no, then don't bother. Oh, this answered the question. All right. What else we got? Let's switch to the next question. All right. From Tomer Shemish. My friend started a company and trademarked the name recently, not registered yet. He now realizes there's a small Etsy company with almost the same name, just with a V in front. Is there something he needs to worry about if they don't have a trademark and it's a small Etsy company? Okay, great question. So, first of all, adding the in front doesn't make any difference. From the trademark law perspective, it's same brand, right? You can't have the Microsoft and expect to get away with that, right? You can't say, well, I'm not selling iPhones, I'm selling the iPhones, right? So from the trademarking perspective, little words like that make no difference whatsoever. So the real question is there a problem that there's another Etsy company under the same name? First question I would ask is, who started first? If your friend started first, then there's no problem at all. If the Etsy company started first, then it's a bit more complicated, because let's say they started first, they're a small Etsy company, and they haven't done anything to protect their brand, they haven't trademarked it, then one of the two things would happen. One, they will never find out about you, about your friend, and his trademark is just going to go register, and he'll own the trademark, and we'll talk about what he can do with that trademark later. But once it registers, it registers. Another possibility, if they somehow find out about your friend, then they would be able to oppose your friend's mark once it gets published for opposition purposes. So first it needs to be approved by the examiner, and once it's approved, it gets published for the opposition purposes for a short period of time, a month in the US, during which anyone can raise their hand and ask the trademarks office not to register their trademarks before they were there first, right? So if they somehow find out about your friend's application that's pending, and they file all the necessary paperwork to attack that application, then he'll get into this fight with them about who started first and all of this stuff. This happens extremely rarely, right? Oppositions happen in less than 1% of the cases. And given that it's a small Etsy company, if your friend doesn't draw their attention to his pending trademark application, the chances of them finding out are slim to none. So let's assume it does get registered, okay? Because then you get the second layer of complexity here. So let's say it registers, and he can enforce his trademark against anyone else, right? Because the registered trademarks gives you presumption of ownership and validity. The only question is, can he enforce it against the Etsy shop? Can he force the Etsy shop to change their name? And here's where you have two different answers. The first answer is by the book, and the second answer is by reality. So by the book, if he goes after them, let's say he sues them, and if they were to respond, right, they were to hire the best attorneys to represent them and fight and prove that, hey, we were there first, and we were selling on Etsy, and we have so many sales that we have established a brand of our own that's a common law trademark. We've sold thousands and thousands and thousands of units under this brand to people all across the US. If they can establish that, then what's going to happen is your friend would still own a federally registered trademark that's enforceable against everybody other than this Etsy company, which is still better than having nothing, right? So the only danger there really is that if this Etsy company somehow gets bigger, but when I say gets bigger, they will not be able to really expand too much, because any expansion that can't be stopped without registered trademark. So, and that's by the book, right? So they will be able to remain as small as they were by the time he filed his trademark application, without being in danger of having to pay for trademark infringement. Having said that, the likelihood of them actually going through through the litigation and proving any of that stuff and paying all the attorney fees to prove that, again, that's also slim to none. If they don't defend, then your friend wins by default. So, and this is really why I keep telling people common law trademarks, yeah, in theory, they're super useful, but relying on your common law trademark when you can simply go ahead and register one is just silly. It's crazy because the cost of proving that you have a common law trademark is at least 10 times more than getting a registered trademark. With a common law trademark, you have to prove it every single time with every single dispute. With a trademark registration, all you got to do is just show them, hey, that's my trademark registration certificate. That proves that I own the trademark. That's all I need, right? That's really the answer. I hope it answers this question. Let's go to the next question. What we got? From Al Siciliano. If I apply for BigFoot as a trademark, can someone else register the BigFoot? Or the BigFoot company. So I sort of covered this already. Yes, adding descriptive words like company or .com or little things like that. Nobody's going to get away with that, right? Because what the Trademarks Office looks at, they look at the dominant part of the trademark. What makes it distinctive from everything else out there? And even if you were to file the BigFoot company, let's say let's assume the other way around, right? So you trademark the BigFoot company, and someone else says, no, I'm just going to go with BigFoot. Right? What the Trademarks Office is going to do is they're going to ignore they're going to ignore company, and they're going to say the dominant part of this is BigFoot. And they would say no, they would refuse any future trademark that's confusingly similar. If we think about, Trademark Factory, right, which we trademarked in a bunch of countries, there's nothing unique about the word trademark in that name, right? So we don't own the word trademark. We own the combination Trademark Factory, right? The putting together the words trademark and factory. So somebody else can trademark something else, right? But they can't use the word factory next to anything that relates to trademark registration services, right? They can't do the Trademark Factory. They can't do the Trademark Factory, company. Which is why when you think of names for your business, you want to come up with things that are distinctive enough for you to be able to enforce them. All right. From Rodless Reel, our loyal subscriber. I see you in every live. Thank you for attending. Appreciate that. So here's the question. I want to put my registered logo on my next fishing reel. Do I have to put the registered symbol on the reel with a logo, or is it still automatically protected? So you do not need to put the R in a circle to have trademark rights. R in a circle is noticed to the world if you want to give it. But even without it, your trademark rights are just as strong. Because with a registered trademark, again, the assumption is that because your trademark is registered, anyone can go to the Trademarks Office and do a trademark search, find your trademark there, and not use a name confusingly similar to yours. Just because nobody does this is their problem. Ignorance of the law is not an excuse for not following the law. So you're not required to put the R next on your fishing reel. There's no requirement. So maybe when you're sold out of all of your existing ones, and you do the next batch, at that point you may want to add R in a circle. It will not hurt, but I wouldn't, trash all of your existing inventory just to replace it with the one that has an R and a circle on it. I hope that answers the question. All right, what we got? Okay, here's a question from Tom McCullough. What advice would you give to new rock bands in choosing a name? Concern is choosing a name only to find other bands with similar names. What's the best approach to navigate our decision making? Okay, great question. Great question. There's no other way around than to do a proper trademark search, just to see what's out there, right? So the first thing I would do, and I think I had a question about this on a regular video that someone posted today. What you really want, whether you're a band or any other business really, you want to have a brand that you can trademark and that you can have a domain name for, right? Having a trademark but not being able to reflect that in an easy to remember domain name is a problem, right? Or social media profiles. So you want to, right? That would be a problem because you have a trademark and then you'd have to explain to people why you're using a completely different domain name. Or the other way around, right? Owning a domain name for a brand that someone else has trademarked is also asking for trouble. So what you want to do is this. First, you do a very simple, quick and dirty Google search yourself, right? And let's say you come up with a name and you see if there are any bands in the same country that use that same name. And if you do find bands that use that same name, I would say, get over it and come up with a new name. One of our clients had a great phrase about that. He says, if you're married to a brand you can't have, get a divorce. So the only exception to that rule is if, let's say, you do a Google search and there's just one band and nobody knows them and they're probably on their way out. You may want to still move forward with that brand as long as you get their consent that you will be taking over the name, right? That's one thing I'd do. The other thing you'd do is you'd see, okay, is the domain name available? If the domain name available, get the domain name, right? $8, not going to hurt you, even if tomorrow you decide to use a completely different name, okay? And the next thing I would do is I would do a proper trademark search, have someone do it for you. Don't just use the free tools out there. When you type in a name and it tells you that no one has trademarked an identical name, and you can't rely on this bullshit because all it gives you is just a knockout search. Or if you use the Trademarks Office's database, then you end up with thousands and thousands of entries that you also have no idea how to navigate, which is why when we do comprehensive trademark search, it takes us several hours of really detailed analysis what's out there. So what I would recommend, like I said, start with Google search. If that doesn't kill the idea, see if the domain name is available. If the domain name is available, get the domain name, and then go to Trademark Factory. Because the way we work is first thing we're going to do after we take your money is we're going to check if the name is available, if it's trademarkable. If it's not trademarkable, we're going to get back to you and say, hey, your brand, the band name that you wanted to go with is not trademarkable because of this, and this. And you're going to have an option of either getting all your money back, which you can do, that doesn't make too much sense to me at your stage, or you can throw other alternatives at us until you pick a name that you love and that we tell you is trademarkable, right? And you would go through the exact same process, right? With those alternatives, you would see, can I get a domain name on those? Can I, are there any other bands on Facebook that use the same name on Google, right? Once that clearance search is clear, then give us the name. We're going to run another trademark search for free. We're going to keep doing this until, like I said, you come up with a name that you like and that we tell you you can own, and you go with that, right? Is there an expense to that? Yeah, of course there is. But you're going to lose so much more money trying to build a name that is then taken away from you, that no matter what you pay for trademark, even if you don't do it with Trademark Factory, you do it with anyone else, right? Getting a trademark, there's virtually never a good reason to choose to go without a trademark than with one, right? Unless, of course, you're planning to, only play for yourselves, in your garage. Then yeah, it doesn't matter what the name is, right? You don't need to trademark that. But as long as you're planning to make that band into a business, you're planning to tour, you're planning to have record deals, you're planning to have merch, you got to own the name. You got to own the name. So I hope that answers that question. What else we got? Another question from Al. Why do I see a lot more TM symbols next to names than the R symbol? Well, it seems that the TM symbol everywhere now and didn't see it much before. So that's a great question. So TM symbol really can mean anything. It can mean that you've got an unregistered trademark that is currently pending in front of the trademark's office. You file your trademark, you put TM next to it. It could also mean that your trademark is registered. You just didn't bother, like Rodless Real, to print new packaging. You still have TM next to your logo, right? So it could mean that you have a registered trademark, but it could also mean that you own nothing. You've never even bothered to file a trademark, because TM, all it means is that you want to tell the world, you want the world to think that you own your brand. That is your brand. That means nothing. There's no legal significance in placing a TM symbol next to anything, right? So, if you look at Trademark Factory's website, right, I can put a TM symbol after every word. Andrei TM, Mincov TM, the founder TM, and there's really nothing anybody can do against me doing this, right? Does it give me any legal rights? No. The reason the reason you see a lot more TM symbols now is because, most people don't register trademarks. Well, you know the statistics, right? 96% of businesses fail. And the reason it happens is because the majority of people who start businesses have no idea what the fuck they're doing, right? They don't know how to build a successful business, and they don't do the things that you need to do to have a successful business. And one of those things is getting your brand properly trademarked. So I hope that answers the question. Just saw a comment from Paula. Yeah, it was your comment about the domain name. I was gonna respond to that later today, and I still will. But it's funny to see you on the live today as well. All right, what else we got? Do we have any more questions? All right, I am being told we don't see any more questions, but I'm happy to hang around, and if anyone has more questions, I'll answer them. And how are we going to do it? Let's see what else we got. And I don't know about you guys. I have so much fun doing these. I really enjoy being here with you live and answering people's questions. Do I play any instruments? Yes, I do. I play the drums, and I play the piano. That's pretty much all I play. And I am, now I'm not going to reveal it now, but there's a massive surprise that all subscribers will see hopefully very soon. Yeah, Nick, I was just going to talk about this and you spoiled it. So yeah, I will show you something that I've built here that's absolutely epic. But there's a few things that I want to do before we do that, and then I'm going to have a videographer come over and make this thing justice. So anyway, that's about me. Yeah, well, do I sing? I stand in front of a microphone and I open my mouth and I try to get some singing out of me. I wish I could sing better than I do, but I enjoy singing, and I love writing my music, and apparently there are very few people who enjoy what I write, but it doesn't matter to me because I write it for myself. I don't plan to to make music a business for me. There are a lot more talented people, but doesn't mean that I don't enjoy trying. Yeah. So let's see. It's more of a conversation now. So let me just see like this. Yeah, cool. Yeah. Thanks, Tom. Yeah. All right, so let's then wrap this up. Unless you have one more question or two more questions or as many questions, but I want to make sure that I'm not just dragging this out longer than necessary. So I see there's a question from Al. So Nick, if you could put this up on the screen, please, and I'll answer that, and we'll be wrapping this up after that. All right, what we got? One sec. All right, we're still learning the system, guys. All right, it's coming any second now. Are we getting there? All right. I gotta see the question on the screen. I can't read from the chat really. So Nick, come on. This is so funny. This is probably the funniest live we've done. Okay. There it comes. And there's also this YouTube delay, right? So all right, if someone registered a completely unique trademark with you and someone asked you to be part of it because of your expertise, would you ever do it? Or do you just register trademarks? Well, it really depends on what me being part of it really means, because if you look at Trademark Factory's website, and this is actually something that's very important to me. Our mission, the way I see it, is to help entrepreneurs build amazing brands, right? Most of what we do, of course, is limited to just helping you register your trademarks, right? Because you can't build an amazing brand without owning it. But if there's something else that people feel that I can help them with to build an amazing brand, then I'm always open to figuring out how can we help people build those amazing brands. Because to me, the really fun part is not filing your trademark, right? That's boring, right? If you think that trademarking is boring to you, right, it's boring to me as well, because it's paperwork, right? Paperwork is paperwork. Paperwork is just bureaucracy. Putting that paper in a frame and mailing to you, yes, that's fun. But the real fun for me begins when I start seeing your products and services in real time, in real life, right? One of our clients here has a trademark, Volt Bike. They sell some really amazing electric bikes, right? And we got their trademark registered in Canada and US early on when they were just starting out. And now I see their bikes everywhere, right? And when I see one, I'm like, I am part of this, right? That's what makes me feel great. We had a client with some revolutionary hair products. Same thing, right? They started with nobody knowing them, and then I started seeing them in pretty much every hair salon. We trademarked the brands for the I'm blanking out. Home cleaning companies that they franchised, and they were acquired by by Brian Scudamore's company, the same company that did 1-800-GOT-JUNK. Okay, I am blanking out. I can't remember them, but again, I see their signs all the time, right? And when I do, I know that we were part of their success, and that's really what makes me happy. That's what makes me tick, right? I build a team of amazing people who do the trademarking part for our clients, and we've got some amazing processes, we've got some amazing offers, and the only reason I do that is because I want to see those success stories, right? I want to see what people can do with our brands, because I realize that not every trademark that we file will ever become a household brand. They won't. I get that, but even if 1% of them does, I still feel great about what we do. So to your question, if there's any value that I can bring, being part of your journey to help you build that brand, you can always reach out and we'll talk. I hope that answers the question. What else we got? Do we have anything else? Where are we going with this? All right. So, and then we'll just wrap this up. So Paula says, send my question but does not go. I don't see the question from Paula. I see a compliment from Paula that I have the best channel on trademarks. Thank you for that. But I don't see the question here. So, oh, there it is. There it is. Nick, you wanna post that? Thanks. You just won't let me go. Okay, give me 1 second. Why would it not let you? Because you need to have it active, Nick. See? When you have it active, it works. When you don't have it active, it doesn't. All right, we figured out the technical part of it. All right, so we're going to have a question from Paula in just a minute, 2 seconds, getting there. All right. Yep. Okay. So here's a question from Paula, and there was another question about sound effects that I really want to answer after this. So let's go with Paula first. If I enter with a trademark application as an intent to use that name in the U.S., and after that some site appears with the same name, but I'm not ready to launch my business yet, what do I do? Okay. It's a great question. That's what intent to use applications are for. You file your trademark before you're ready to put your products or services on the market, and you have some time to start using. So the way it works is when you file your trademark, typically going to take about a year, maybe a year and a half in the U.S. now for that trademark to go through. After that, so you get this initial period during which it's getting examined, and you don't have to have use, and then it's going to be approved, then it's going to survive opposition period, and then it's going to get allowed. At that point, they give you 6 months to show to the trademarks office that you've started using the brand. If you haven't started using the brand 6 months after the allowance, you can request an extension of time for another 6 months. And it costs $125, I think, the government fee per class to ask for that extension. And you get another 6 months. And then you can do it again and again and again and again. So you have up to 5 extensions, giving you a total of 3 years after the initial allowance. So if you add all of that up, right, realistically you have about 4 years that you can keep requesting those extensions. When you file your trademark based on intent to use, you are expected to genuinely intend to start using your mark, within 2-3 years from that filing, and that's how it works. So let's say you file your trademark as an intent to use, someone else goes out there, so your trademark won't register until you start using, but your application will still give you the rights to go after them. So what's going to happen is you can still have your attorneys send them a letter saying, hey, I was here first, I filed my trademark, and you shouldn't be naming your products this, because once my trademark registers, I'm going to go after you and I'm going to take all of your money. So that's really how it works. The only danger to this strategy when you go after people before your trademark registers is that this will alert them during the opposition period, so they can oppose your mark. So what you can do is you wait till your trademark gets allowed, so it survives the opposition period, then you go after them and say, hey, I may not have started using it, but just because I haven't doesn't mean that you can, because I've got the allowed trademark, and all it takes for me is to sell one item, and I will get this trademark registered. So don't be stupid, change your name, because I'm going to go after you if you don't. That's really how it works. All right. Let's see. This is another question about the sound effects. There we go, from Josh Cohen. Is it more difficult to trademark sound effects like the sounds when you open Netflix or Disney Plus? Yes. These are called the non-traditional trademarks. So traditional trademarks are words, right? Phrases, logos, everything. Well, colors are sort of getting there, but rarely when you're just trademarking the color by itself, right? It still has to be applied to a surface of an object. But sound effects, they are much rarer. That's why it's more difficult, right? They have to be very distinctive. So it has to be something that you can describe. It has to be something that's not commonly used for that particular type of product or service. So if it's a jingle, it's easier. If it's really a sound effect, like, you know, like a pop or just like really something very short, that gets harder to trademark. The Roaring Lion of MGM was one of those most famous sound trademarks. And some countries recognize them, some countries don't. So in the US, they're more common than in many other countries. So, for example, Canada only started allowing them in the last few years. So, you know, to answer your question, yes, it's more difficult because you have to provide more evidence, and you just don't go through the same forms that you typically do with all the other ones, because there's sound, right? But it's still something that can be done. Yep. I hope that answers your question. So, where do we go from here? Do we have more, or are we done? And by the way, I will be doing these. I'm planning to continue doing these lives every 2 weeks, every second Thursday. We'll see if anything changes, but really happy to be here with you. Yeah, one thing I didn't mention. So in the top left corner, you guys see we put up a new page, which is basically just a directory of all of our links that you can go to, tmfacts.com. From there, you can go to book a call with one of our strategy advisors if you have a brand that you want to protect. There's also a link to the course that I put out with a promo code that you can use to get 75% off. Like if you really want to learn about trademarks from start to finish and have a very good understanding, I mean, it's not going to make you a trademark attorney or anything like that, but it's going to give you enough understanding about how the whole thing works. We also launched our affiliate program a couple of weeks ago. So if you know somebody who could benefit from trademarking their brand with us, we'd be more than happy to send you $500 commission for sending us a new client. So if you want to sign up as a Trademark Factory affiliate, you'll find a link there. If you want to see some other resources, we got a ton of stuff we're giving away for free on the website. So you'll find them all there in tmfacts.com. And that would be it for today. Thank you so much for being here today with me. I really enjoy this, and I'll see you in the next video. Just when I was gonna sign off, there's another question. So Nick, do you think I should answer it, or do you think we should be done? Okay, so Nick says he'll save it for the next time. We'll answer that question in 2 weeks' time, and so the lives are going to happen on Thursdays. So what's the next day? So it's the 24th, and then it's going to be the 10th of March. So 10th of March, we're planning to do that. All right.
No business can be successful long-term unless it has trademarked its brand.
So as a responsible investor, I want to make sure the company I'm planning to invest in has trademarked its brand.
You can make great profits selling your products or services today, but if you don't own your brand, then you don't have a business that's set up for lasting success.
If there's one thing I've learned about brands, is that your brand is not worth much if you don't own it.
And the only way to make sure you own your brand is to trademark your brand before somebody else does.
Speak to sell. It's our trademark, and that has given us a lot of power. We've done over $40 million of sales from this home-based business. And I know that a lot of it is, that when you name the game, and I'll add that you trademark the game, you own the game.
There's literally no point in building a brand unless you own your name. So one of the first things we did in 1977 was we went ahead and trademarked the name Twisted Sister.
You can't ever use the name FUBU anywhere in the world. A universal trademark costs $50,000, but I started off with just $2,500.
I was able to stand to multi-billion-dollar bullies is because I registered my trademarks and I did it correctly. That was one of the most important things I've ever done.
All the things that you put into, designing, branding, getting people to know, and that kind of thing is now protective and can't be taken by someone brand new into the market who has an idea and just scoops it up and runs away with it.
I recommend to entrepreneurs, it's very, very important to trademark your name and protect your name in advance. If you're going to spend any effort, time, effort, money in promoting your brand and growing your business, you have to protect your brand like day one.
So if you're out there trying to get the world to discover your business, you got to trademark your brand right away before it's too late. Why would you spend time, money, and effort building a brand you don't own?
Taking ownership of your brand isn't a luxury, it's a necessity.
That's why I want to give a big shout out to Trademark Factory, the only firm in the world that offers trademarking services with a guaranteed result for a guaranteed budget.
Big shout out to Trademark Factory.
I want to give a big shout out to Trademark Factory.
And I want to give a big shout out to a company that can help you trademark your brand like nobody else will. It's called Trademark Factory. They offer trademarking services with a guaranteed result for a guaranteed budget. I mean, you pay once and you either get your trademark or you get your money back. No other firm that I know of offers anything like that.
You pay once and you either get your trademark or you get a full 100% refund. Now that's what I like a lot about it.
I've spent, tens of thousands of dollars on trademarking over 20 years. And protecting my assets. And when I found Andrei, it was just a whole different experience. Gave me a quote up front, lived to the quote, delivered exactly what he said he was going to deliver. And it was just so wonderful to see these trademarking certificates just appear in the mail, and you open them up and you know that it's done. Yeah, there it is. Yeah, and you know
a blue
that it's,
bubble envelope.
Yeah, and it's just the coolest thing.
What's really cool about Trademark Factory is they offer trademark services with a guaranteed result and a guaranteed budget. No other firm that I know of offers anything like this. It's literally lights out for all trademark services out there.
You pay once, and that one fee covers everything from filing to registration. Trademark Factory can help you trademark your brand in the US, Canada, and pretty much anywhere else in the world. And the best part is, if your trademark doesn't go through, you get all your money back. Nobody else does this. Only Trademark Factory does this. So if you want your trademark done right with a 100% money back guarantee, check out Trademark Factory and see if they can help you protect your brand.
So if you're thinking of getting a trademark, I definitely recommend you check out Trademark Factory.
If you want your trademarks done right, check out Trademark Factory.
Trademark Factory! Yeah!
If you value your brand, your time, and your money, check out Trademark Factory. They're the real deal.
Get it trademarked with Trademark Factory!